Is the interview. Respondent has been active. Covered case?
Yes, ma'am.
Covered case? You have seen it?
Yes, sir.
First appeal number 30 of 2008. कल थोड़ा सा लिखाए थे, that will be incorporated over here. This appeal has been filed against a judgment dated 14/8/2007, passed in LR case number 458 of 1992. There are two cases. And LR case number 5 of 86/87. ये and कैसे है? How is this and LA case number? Is it arising out of LA case number 5 of 86/87? कुछ नहीं पता है, टाइम नहीं मिलता है घर में ना देखने के लिए. Look at your memo of appeal. And तो नहीं होगा ना, corresponding to होगा as per the first appellate court's judgment which has been disposed of. Corresponding to land acquisition case number 5 of 86/87, passed by the learned subordinate judge Roman 2 cum special judge land acquisition Hazaribagh, by which the reference was allowed along with other analogous cases, holding that the rates of land should be assessed and treated at rupees 2,800 per decimal for giving compensation to the awardees. The aforesaid judgment, the impugned judgment, is common judgment in connection with numerous LR cases, total 51 in number. Right from LR case number 411 of 1992 to 461 of 1992. The learned counsel for the appellant has submitted that first appeal number 10 of 2008 has been decided in connection with one of the reference cases involved in the impugned judgment, bearing reference case number 424 of 1992, and has been disposed of by judgment dated 12th of June 2019. She has submitted that the matter was remanded to the concerned court by observing that it was not mentioned in the interim judgment as to on what basis the compensation at the rate of rupees 2,800 per decimal has been arrived at, and the finding of the learned court about the market value was not supported by any reasons, and the finding was not in consonance with the documentary evidence on record. The learned counsel submits that this appeal be disposed of in the same terms and there is no distinguishing feature, as the entire batch was decided on the same set of evidence based on that.
There is one more case that is pending, which is listed at 12
Aaj
under orders. It's pending for appearance in this one.
we'll see that. वो फाइल कर ले तो orders वाला.
Let's see the full. FA 22.
Nobody has entered appearance on behalf of the respondents in spite of substituted service of notice. However, one intervention application has been filed, primarily with the grievance that the intervener is entitled for a portion of the awarded amount.
Entire awarded amount.
And it is a claim of the intervener that they are entitled for the entire awarded amount.
As per the compromise in LR case,
And the claim is based on certain compromise in LR case number
526 of 92.
526 of
92.
526 of 90.
576.
LR case number 576 of 1992. Which, as per the intervener, was decided after the passing of the interim judgment, and the decision was under section 30 of the Land Acquisition Act. After hearing the learned counsel for the appellant and the intervener, this court finds that the batch of LR cases which were numerous cases out of the batch of the LR cases which were disposed of by the interim judgment have been ultimately disposed of by this court in first appeal number 10 of 2008. And under such circumstances, the present LR case is all the present appeal arising out of LR case number 458 of 1992 is also disposed of in the same terms. The findings recorded in first appeal number 10 of 2008 in paragraph 11 to 13 are as under. 11 to 14 is quoted as under. This appeal is also disposed of in the same terms. The impugned judgment relating to LR case number 458 of 1992 is hereby set aside. And the matter is remanded back to the court concerned for fresh decision in accordance with law. The appellant to enter into, to appear before the learned court on, I'll give a date. Since that should be sufficient. So far as the interlocutory application seeking intervention is concerned, since the matter has been remanded back to the concerned court, this court is not inclined to allow the intervention application. However, it will be open to the intervener to take appropriate steps as may be permissible under law. Are you closed? ये कौन सा? दूसरा का रिकॉर्ड है ना?
Serial 12, that is.
सीरियल 12. इसमें क्या चल रहा है?
Notices were issued, earlier notices were issued only to the sons. Thereafter, daughters were, we came to know knowledge that daughters are also there.
Okay.
So, daughters were also issued notices. However, it was received by the brother. Thereafter, fresh direction was made for fresh issuance of notice to the daughters. And that has been done with leadership in the correct practice.
इसमें तो उसमें भी लिख देंगे lower court records are not required. Here also lower court records are not required. It is covered. No wakalatnama has been filed by respondent number 15218.
They are the daughters of the respondent.
14151618. SR received. 14 has been personally served. 15 has been served through husband. 16 personally served. 17 personally served. 18 SR has not yet been received. 18 का नहीं आया है. Nobody has entered appearance now. रजिस्टर्ड नोटिस किया था यहाँ से पुलिस स्टेशन से कर देते हैं पुलिस स्टेशन से कर वो एग्जैक्टली खोज खाज के निकाल देते हैं
Leadership, so far as 4 to 7 are concerned, they have been validly served.
Yes, I will record that.
And what instructions that I have received leadership, though it may not be proper in law leadership, but what instructions I have received is that the brother is the one who pursues this cases on behalf of every other member of the family. But I know it cannot be taken up in law leadership.
You see, whatever substitution is being done over here, it is only for the purposes of this case. At the time of remittance, everything is required to be done.
Leadership, that is it.
Right. यहाँ पे तो क्योंकि कुछ इंक्वायरी होता नहीं है, parties are also not assisting properly. कभी कभी गलत नाम आ जाता है, स्पेलिंग मिस्टेक हो जाने से दिक्कत है. देयर आर सो मेनी थिंग्स.
Petition that.
देखिए FA number 22 of 2008. Notices were issued to respondent number 1 within bracket 4 to 1 within bracket Roman 8 under registered cover as well as ordinary process. As per service report of ordinary process, the notice has been personally served or through close relation to respondent number 14 to 17. Counsel for the appellant has submitted that the notice be accepted as validly served. Considering the office note and the submission of the counsel for the appellant, notice upon respondent number 14 to 17 is accepted as valid. So far as respondent number 1 within bracket 8 is concerned, the service report has not yet been received. The counsel for the appellant is directed to take press steps for service of notice upon respondent number 1 within bracket 8 through the concerned police station. The requisites will be filed by the applicant. Post this case, awaiting state party है इसमें. State is party. or not
Petition,
party?
DC is party.
नहीं होगा, state party नहीं होगा.
DC.
DC is not a party. कोई बात. हाँ,
नहीं,
DC party है. Respond number 5. Who are you?
We are from the same office.
Since nobody is appearing on behalf of respondent number 5, स्टेट बोल के तो पार्टी नहीं है ना, कोई बात नहीं, आ जाएगा सर्विस रिपोर्ट. दे सेंड इट. At the time of serving the notice upon respondent number 1 within bracket 8, इतना लिखने का जरूरत नहीं, पुलिस स्टेशन से कराते हैं इसको. ये लास्ट लाइन भी छोड़ देंगे. पोस्ट दिस केस ऑन 22nd September, awaiting service report. परसों तक फाइल करें.
Okay, sure.
23rd September in supplementary process.
Right.
Item 2 from supplementary list second appeal
Open this window.
Your lordship.
Yes.
7190 of 2022.
This is
कितना
my
अच्छा आपका जूनियर बहुत अच्छा बहस करते हैं. He started it yesterday.
lordship.
He really argues well. He knows the subject quite
Lordship.
well. चलिए ठीक है, आपको बढ़िया से असिस्ट करेंगे.
This is my lords, the plaintiff's second appeal against the judgment of affirmance.
Yes.
Lordship, the appeal has been admitted by terms of order dated 5/2/2025.
Yes.
Lordship may kindly see the order dated 5/2/2025.
5-2. He 6-2.
Lordship, 5.
5-2. 6-2 का order है.
I'm sorry, your 6/2.
पढ़िए.
This appeal is admitted for hearing on the substantial question of law number 2 mentioned in the memo of appeal. Whether both the learned courts below erred in not considering that when the defendants have admitted the salary disputed by Gunadhar Bose in favor of plaintiffs and further admitted that original Rayat Jagannath Napit and his son Gopal Napit had sold some plots of land to Ganadhar Bose and further came with a defense that Gunadhar Bose did not have possession of 9 decimals of land, rather only 6.5 decimals. Then onus of proving of such fact was with the defendant. Now, Lordship may kindly see, additional substantial question of law, my lord, was formulated by terms of order dated 18/6/2025, order number 11. Lordship, whether both the learned courts erred in not considering the admitted case of the defendants that Gunadhar Ghosh was left with 13 decimals of land out of his total land of 19 and half decimals. After he had sold 6 and half decimals of land to defendants, and further when plaintiffs proved their possession over 9 decimals of land purchased from Gunadhar Ghosh by way of registered sale deed, mutation and rent receipts, plaintiffs were successful in proving their right, title and interest over the suit land. Now, Lordship may kindly see, suit was filed, my lord, for declaration of title,
Plain.
Lordship. Suit was filed, Lordship, for declaration of title and confirmation of possession in the alternative, my lord, for recovery of possession and for declaration, my lord, that the sale deed dated 6/6/1992 is a forged and fabricated document and the same was never acted upon. Now, my lord, the case of the plaintiff as set out in the plain is that, my lord, the mother of the plaintiff, namely Lordship Saraswati Devi, purchased, Lordship, 9 decimals of land appertaining to plot number
Just a
259.
Just a moment.
Lordship.
The entire dispute is relating to khata number 20, plot number 259.
Lordship.
Let me just note it down. Khata number 20, plot number 259. What are these two schedules? Schedule A and B?
Schedule A, my lord, page 14,
It is the purchase by mother.
mother, Lordship.
And what is schedule B?
Schedule B, my lord, which is the portion of Schedule A land and dispute is with respect to Schedule B land.
So, as per schedule A, the area is
9 decimals, Lordship.
9.
9 decimals, Lordship, appertaining to plot number 259 of
That's
khata number 20.
This is saying this is mother's sale.
Lordship, which has been purchased, my lord, by the mother of the plaintiff,
Yes.
namely Saraswati Devi, by virtue of registered sale deed dated 10/11/1982 from one, my lord, Gunadhar Ghosh. And the entire area of Lordship, entire area of plot number 259 of khata number 20 is 64 decimals.
Entire area is
64 decimals.
64. From where do I get this?
Lordship, I have stated in my plain.
Where is it mentioned?
And my lord, the
Where is it mentioned? That is
Yes.
important, very important.
paragraph 5 onwards, Lordship.
Para 5. An absolute owner. The owner
And-
was Jagannath Napit.
Napit,
Original owner
Jagannath Napit.
Napit. 64 decimals.
64 decimals. Out of which, my lord, Jagannath Napit sold 11 decimals of land
Decimal. To
to one Bajnath Mandal.
by registered sale deed
Lordship,
number
dated 28/11/1971.
28 12
Lordship.
1271.
Thereafter, my lord, Jagannath Napit again sold 9 decimals of land to one R.C. Sharma.
It's 9 This one. R.C. Sharma. Registered deed number.
Number 3315 dated 11/5/1971.
11/5/1971.
Then Milord Jagannath Napit again sold 9 decimals of land to Gunadhar Ghosh. This is important.
9 decimal to Gunadhar Ghosh.
By virtue of Milord registered sale deed dated 9/1/1973.
9/1/1973.
Being deed number 165.
165. We did this, and this property was sold to the mother.
Lordship. Thereafter, Milord, after the death of Jagannath Napit, his son, Milord, namely Gopal Napit, sold 7 decimals of land
7 decimal to
to one R.K. Singh.
R.K. Singh. Registered sale deed number.
Number, Lordship, 4415 dated 24/7/1973.
4415
Dated, Lordship, 24/7/1973.
73. Okay. Then further.
Then, Milord, Gopal Napit again sold 5 decimals of land
This one to
to one Darshan Singh
Singh.
by registered sale deed, Lordship, dated 22/4/1974.
Number
Number, Lordship, 3892.
3892. Okay.
Then, Milord, Gopal Napit again sold 6 decimals of land to one Aswini Ghosh
Yes.
by registered sale deed, Lordship, dated 10/9/1974, being deed number 8918.
74. Yes.
Then, Milord, Gopal Napit also sold 13 decimals of land to Gunadhar Ghosh. This is also important.
Ghosh. By sale deed number
132
132.
dated 31/5/1975.
Okay.
Thereafter, Milord, Gopal Napit again sold 2 decimals of land to R.C. Sharma.
Deed number
By registered sale deed dated 31/5/1975, being deed number, Lordship, 5039.
So Napit and company,
Lordship,
they sold how much? Out
62 decimals?
of entire.
62 out of 64. Land sold by Jagannath Napit, Lordship, 29 decimals, and land sold by Gopal Napit, 33 decimals. Total 62
Just
decimals.
Gopal Napit, how much? 33
33 decimals,
decimals.
and land sold by Jagannath Napit, Lordship, 29 decimals.
62. Out of 64.
64. We are,
Mutation also done?
yes, Lordship.
For all these deeds mutation done?
Lordship. And our name, Milord, the name of the mother of the plaintiff was also mutated in the revenue records,
Yes.
and Milord, rent receipts are being issued in the name of the mother of the plaintiff, which has already been exhibited. Sale deed has been exhibited, rent receipt has been exhibited.
So what's the story further?
Now, my lord.
Just a moment. Likhit, the learned counsel for the appellant has submitted that the dispute relates to Khata number 20, plot number 259, which had total area of 64 decimal, and it originally belonged to Jagannath Napik. He has stated that the following sale deeds were executed by Jagannath Napik. 1. 11 decimal to Baznath Mandal by sale deed number 6064 dated 28/12/71. 9 decimal to R.C. Sharma by deed number 3315 dated 11/5/1971. 9 decimal to Gunadhar Ghosh by deed number 165 dated 9/1/1973. After death of Jagannath Napik, his son, namely
Gopal Napik.
Gopal Napik, executed the following sale deeds. 7 decimal to R.K. Singh by registered sale deed number 4415 dated 24/7/1973. 5 decimal to Darshan Singh by registered sale deed number 3892 dated 22/4/1974. 6 decimal to Ashwini Ghosh by sale deed number 8918 dated 10/9/1974. 13 decimal to Gunadhar Ghosh by sale deed number 132 dated 31/5/1975. 2 decimal to R.C. Sharma by sale deed number 5039 dated 31/5/1975. Thus, Jagannath Napik sold 29 decimal during his lifetime, and Gopal Napik sold 33 decimal, total being 62 decimal out of 64 decimal. He has also submitted that the entire 9 decimal of land which was sold by Jagannath Napik to Gunadhar Ghosh by sale deed number 165 dated 9/1/73 was sold to the mother of the plaintiffs, namely Srimati Saraswati Devi, by sale deed number 4080 dated 10/11/1982, which is mentioned in Schedule A of the plaintiff.
Lordship. Now, Lordship may kindly see. The defendant, my lord, claims to have purchased.
No, just a moment.
Lordship.
Thereafter, what is the cause of action?
Thereafter, my lord, there was a proceeding under section 144 CRPC at the instance of defendant.
Okay.
They started laying false claim over the lands belonging to the plaintiff.
That is Schedule A.
Schedule A.
Okay.
Thereafter, my lord, there was a proceeding under section 144 CRPC, which was ultimately, Lordship, dropped, and thereafter.
And thereafter the case was filed.
Yes, Lord.
What is the case of the defendant? So how the Schedule B has come?
Because, my lord,
Because they were claiming only over Schedule B.
Lordship.
Schedule B is how much?
Schedule B is, Lordship, about 2.5 decimals.
The learned counsel for the appellant has also referred to Schedule B of the property, which is a dispute involved in this case, and
About 2.5.
which is a part of Schedule A. And the description of the property in Schedule B reveal that the dispute is in connection with north-south measuring 66 feet into 17 feet and in some part 15 feet, consisting of well on the northern side and angan and open garden in portion of plot number 259, khata number 20.
Lordship.
The boundary has also been provided in Schedule B. North is Prabhu Patel, south is Bihar Sarkar, now Jharkhand Sarkar, east is dependent, west is plaintiff's building and remaining part of the purchased land. He submits that in connection with Schedule B property, there was a proceeding under section 144 of CRPC, and ultimately the suit was filed to dissolve the dispute.
Now, my lord, the case of the defendant is that, my lord, they are claiming to have purchased 6.5 decimals of land.
Who are the dependents? What is their name?
Their Lordship, Initially, my lord, original dependent was Mohan Jaiswal.
Okay.
Mohan Jaiswal died during dependency of this
That's right.
lord.
So the Mohan Jaiswal had purchased 6.5 decimal of land from
Land, my lord, in the year 1976,
date.
with respect, lordship, from Gunadhar Ghosh by registered sale deed dated
Registered sale deed number. Registered sale deed number.
number lordship 1480
1480
dated 9/3/1976.
1976. Mutation done.
They have not stated anything, my lord, in the written statement.
Yes, mutation was done.
Regarding-
Yes, that has been stated in the written statement. as a-
Exhibited.
Exhibited.
Okay, mutation done.
My learned friend may kindly go through that.
Okay. So from Gunadhar Ghosh he purchased 6.5 decimal.
6.5
So
decimal
Gunadhar Ghosh had total 9 decimal and
and 30,
9 plus 30.
9 plus 30.
So
So, my lord, we have no manner
9
of concern,
plus 30.
lordship. We have no manner of concern with the land, my lord, purchased by the dependent. Rather, my lord, we have purchased the land by virtue of a registered sale deed from its rightful owner, my lord, namely Gunadhar Ghosh. And Gunadhar Ghosh has purchased the land from the original owner, namely Jagannath Nape.
So this description as to how the property has devolved must be there in the sale deeds also. These have been exhibited
Lordship, my sale deed has been exhibited,
and dependent sale deed has not been exhibited.
defendant sale deed has been exhibited.
Right. So it must be mentioned in the sale deed as to how the property is devolved.
Manner of acquisition,
Certainly.
Lordship.
Because Gunadhar Ghosh has 2 sale deeds in his favor.
Lordship,
So we have to see if there is any overlap between the two. There is the possibility. What
Lordship.
are the exhibits?
My sale deed has been exhibited, Lordship, but other sale deed, my lord, has not been exhibited.
Other sale deed means?
Other sale deed by which, my lord, by which Jagannath Napi sold the lands to different purchasers.
So, but Gunadhar Ghosh,
Lordship,
he purchased by 2 sale deeds.
by 2 sales.
Both must have been exhibited.
Those sale deeds have not been exhibited, Lordship.
No. The
By
sale-
which Gunadhar Ghosh has purchased the land. My sale deed has
At
been
least in the
exhibited.
sale deed, the description must be there.
My sale deed has been exhibited.
So your sale deed is which exhibit?
My sale deed, Lordship, exhibit 2, certified copy of sale deed dated 10/11/1982. And rent receipts are exhibit 1 series.
You see, Gunadhar Gop has mentioned about his title in the sale deed, right?
In the
sale
sale
deed,
executed and registered in favor of the
Said
mother.
seller has acquired by virtue of purchase by registered sale deed number. उसके बाद number का आएगा. $165 यही है.
160.
165.
160.
9170.
9170.
So this is back to back, as per this.
Lordship.
And this is your purchase document.
This is my sale deed, Lordship. And Lordship may kindly see Exhibit 1 series, which is Milord Red receipt issued
That's
by
it.
the revenue.
What about the defendant's sale deed?
Defendant sale deed, Lordship. Exhibit B, B, B1 and B by 2.
एक ही सेल डीड होगा ना उनका?
नहीं, दो
दो क्यों?
दो
आपको
इसलिए
दूसरा का तो नहीं पता
नहीं,
है?
दूसरा वो परचेज की है 1992 में 7.5 decimal by registered sale deed dated 6 from Milord the legal heirs of Gopal Napi.
There is one more sale deed ना?
One more.
Three sale deeds are there. So
बताइए.
defendants are concerned. Three
आपका डिपेंडेंट का 3 सेल डीड
three
है.
registered sale deeds.
बताइए जरा डिपेंडेंट का.
Exhibit B, B by 1 and B by 2.
Just a moment. One is 1480 dated 9376.
Yes.
This is exhibit.
Yes, Exhibit B.
Exhibit B. दूसरा बताइए.
Another is 6692.
Deed number
And deed number is 2813.
dated 6692.
92.
692. Purchased from
From Gopal Napi, son of late Jagannath Napi. This sale deed was
just a moment.
imputed by them.
Gopal Napik. What is the area?
7.5 decimals.
How do you get 7.5 decimal? There was only remaining 2 decimal.
So far as this sale deed is concerned, at that point of time, this sale deed was executed and I was put in possession.
No, we do not know because this is 1992 sale deed
92 sale deed.
and Gopal Napik. This Gopal Napik, so far as plaintiffs are concerned, none of the sale deeds of Gopal Napik, all the sale deeds of Gopal Napik which plaintiffs have referred are prior to 6/6/1992.
Now one thing is there, all the said sale deeds which has been referred, those are not exhibit. Now we do not know whether it relates to this plot to 59. And that is the reason the finding has also been given by the learned.
Okay, just we'll come to that. So according to you, 2813 dated 6/6/1992, Gopal Napik sold 7.5 decimal to the defendant.
Yes.
Okay. What other sale deed?
It is 26/11/94,
2611 sale deed number
3388.
3388. This was purchased from
From Aswini Ghosh.
who is he?
Aswini Ghosh purchased the land from Gopal Napi, 10/9/1974.
Just a moment. Purchase from Gopal Napik 10/9/74
Yes.
and you purchased it from Ashwini Ghosh.
Aswini Ghosh.
Okay. Area
6 decimals.
okay. The learned counsel for the appellant has submitted that the defendant, namely Mohan, the original defendant, namely Mohan Jaiswal, has claimed that he had purchased 6.5 decimal from Gunadhar Ghosh, white, sale deed number 1480 dated 9/3/1976, Exhibit B. Further, he purchased 7.5 decimal white, sale deed number 2813 dated 6/6/1992 from Gopal Napik, within bracket exhibit number
B1.
Exhibit B by 1, and again purchased 6 dismil of land by sale number 3388 dated 26/11/1994 from Ashwini Ghosh, who had purchased from Gopal Napit by sale deed number dated 10/9/1974, right? Until 10/9/74 has been exhibited.
No, that is not.
The sale deed dated 10/9/74 has not been exhibited, and 26/11/1994 deed has been exhibited.
6/11/94. Yes, that is exhibit B2.
26/11/94 में ब्रैकेट में एग्जिबिट B by 2 लिखेंगे, और ये 6/6/1992
That is B1.
एग्जिबिट B by 1. This is exhibit B by 1. राइट, तो आपका थर्ड वाला का बैक टू बैक जो भी सेल डीड है वो नहीं है. During the course of arguments, it also transpired that the plaintiff has exhibited the sale deed in connection with Schedule A property in the name of his mother as exhibit 1.
Exhibit 2 है.
Exhibit 2, Lordship.
इसके अलावा आपका कोई सेल डीड है?
नहीं, एक ही
No
से-
other sale deed has been exhibited by the plaintiff, including the sale deed number
4080 हमारा सेट है.
including the sale deed number 165 dated 9/1973, sold by, said to have been sold by Jagannath Napit in favor of Gunadhar Ghosh, who is the vendor of the mother of the plaintiffs. However, the sale deed number 165 dated 9/173 has been mentioned in the sale deed exhibit 2. ठीक है?
जी.
अब बताइए, आगे का कहानी सुनाइए. Finding क्या है learned court?
Lordship में kindly see.
So the entire finding is revolving around identity of the property.
Now Lordship में kindly see. Issues framed by the trial court. Internal page 9.
Yes, please.
Issue number 7 is important, Lordship.
You read all the issues.
Lordship, whether the suit is maintainable in its present form or for the relief claim, whether the plaintiffs have got valid cause of action to file the suit, whether the suit is barred by law of limitation, a specific relief act, and under the provision of estoppel, waiver, and acquiescence, whether the suit is barred by for want of necessary parties, whether the description of the suit land is vague and incorrect, whether the suit is undervalued, whether the plaintiffs have got right, title, and interest over the suit land by virtue of registered sale deed dated number 4080 dated 10/11/1982. Then below, whether the sale deed number 2813 dated 6/6/1992 is a false and fabricated deed and the same was never acted upon. Now, Lordship, whether the plaintiffs are entitled for any relief or reliefs as claimed. Now, Lordship, may kindly see issue number 7 and 8, my lord. It has
What happened to issue number 3? Issue number 3, limitation, specific relief act. What is the finding? Because limitation में है, कहानी तो खत्म है, फिर तो कोई भी कितना ही मेरिट क्यों ना हो. It has got nothing can be done. What is the finding on limitation?
issue number, Lordship, may kindly see page internal page 25. Issue number 3 and 5 is decided in favor of the plaintiff.
So on point of limitation, there is concurrent finding.
Lordship,
So ये सब का काम खत्म. All right.
they have not preferred any cross
That's
appeal.
it. No problem.
Now, Lordship may kindly see the findings recorded by the learned trial court with respect to issue number 7 and 8,
That's right.
which has been dealt with, my lord, in para 22 of the trial court judgment.
22. Yes, please read it slowly.
Lordship. These are main issues and interlinked with each other so for the sake of convenience and better appreciation of the evidence available on the record. These issues are taken up together. The plaintiff's case in crux is that suit land is part and parcel of plot number 259, and Srimati Saraswati Devi, wife of Deepti Singh, purchased the portion of plot number 259 measuring an area of 9 decimals from khata number 20 from Rayat and previous purchaser Ganadhar Ghosh, son of Gati Ghosh of Balrampur, PS Gamharia, by virtue of registered sale deed number 4080 on payment of adequate consideration amount of 9 decimals of land from the said vendor, and the said Saraswati Devi enjoyed and possessed said land on her Rayati right in mutation case number 280 of 1987, and the circle officer mutated her name after thorough inquiry and finding her possession in the purchased land. It is further case of the plaintiff that the original owner Jagannath Napi, with respect of the land of khata number 20 of Moja Balrampur, was absolute owner of plot number 259 and area of 64 decimals of plot number 258. It is also the crux of the plaintiff that Jagannath Napit and his son Gopal Napit sold 62 decimals of land to different persons. So the question of purchase of 7.5 decimals of land out of khata number 20, plot number 259 cannot be at all accepted.
This is the crux. 24 is the details of the various entities which we have already given.
Lordship.
Come to para 28.
Para 25.
25 yes.
Lordship. Now I find that it is the case of the defendant that Gunadhar Ghosh never sold and could not have sold an area of 9 decimals to the plaintiff's mother, possession of only 6.5 decimals of land in plot number 259, khata number 20, village Balrampur, which he required by purchase in 1973, and the plaintiff's mother never purchased an area of 9 decimals on the basis of alleged sale deed. I further find that the defendants have not challenged the sale deed number 4080 dated 10/11/1982, but the area mentioned is challenged. That then Ganadhar Ghosh never sold and could not sold an area of 9 decimals of land to the plaintiff's mother, as he was in possession of only 6.5 decimals of plot number 259 of khata number 20 of village Balrampur, which he acquired by purchase in 1973. Now I find that burden lies heavily on the plaintiff to prove that there was 64 decimals of land of suit land, which is part of khata number 20, plot number 259 in the Goda 3, area 9 Bismil, founded by Bihar Sarkar, now Jharkhand Sarkar, South Paresh Nayak, East Jagannath, and West Bihar Sarkar, as per registered sale deed dated 10/11/1982. And the burden of proof is also lies on the plaintiff that out of khata number 20, plot number 259 of Moja Balrampur, is Gamharia, that out of 64 decimals of land was transferred to different persons as mentioned above, and since the property remained only 2 decimals after the aforesaid sale since 1971 up to 1975, in this regard I find that PW 1, 2, 3, 4, 5, one of in examination in chief has stated that about 26 years ago, plaintiff's mother Saraswati Devi purchased 9 decimals of land from Gunadhar Ghosh by registered sale deed and also got possession and mutated land in her favor and the parents of the plaintiff on the northern side of the constructed house and on the southwestern side erected the boundary and also dug a well on the northwestern side and used vacant land for horticulture and could not raise boundary on the eastern side because of financial crisis. I further find that PW 1, 2, 3 and 4 have not whispered that out of 64 decimals of land of Khata number 20, plot number 259, 62 decimals of land was sold from 71 to 75 by different registered sale deed by Jagannath Napit and his son Gopal Napit. I find that this fact, however, plaintiff himself as PW 5 in examination in chief has stated that in Khata number 20, plot number 259, 64 decimals worth of land was sold till 31/5/19.
There is a conflict in the PW's evidence. On the one hand, nobody has stated that 62 decimal of land was sold as per the plaintiff, and the plaintiff has stated in his evidence that 64 decimal of land was sold till 31/5/1975.
Plaintiff has stated.
Plaintiff has stated.
Lordship. In cross-examination, he admitted before the court. This fact has been admitted by the defendant in his written statement, Lordship mechanism,
Okay.
that the land has been sold by the original owner and his son to different purchasers. They have not denied.
Is it a fact that the defendant also admitted that the total area was 64 decimal?
No. Lordship mechanism.
That has not been admitted.
Lordship mechanism.
Kindly read it, will come to the record.
Lordship. So no question arises. That defendant purchased 7.5 decimals. In cross-examination, he admitted before the court that he had not seen the old Khatiyan of the suit land. However, he has seen the Khatiyan of 1964 survey. He also deposed before the court that when he was young, that time his mother purchased land in which he is not the witness. From the perusal of the cross-examination of PW5, I find PW5 supported his mother had purchased 9 decimals of land from Gunadhar Ghosh on 10/11/1982, but this fact has not been proved by other PWs. While it is the case of the defendant, Lordship, that Gunadhar Ghosh never sold and could not have sold an area of 9 decimals to the plaintiff's mother, as he himself was in possession of only 6.5 decimals in plot number 259 of Khata number 20 of village Balrampur, which he acquired by purchase in 1973. But Lordship will find that the defendant has not challenged the sale deed executed and registered in favor of the mother of the plaintiff in the year 1982 by filing suit. Even if my lord is aware of the judgment of the Honorable Apex Court that even if a document is void, the same is required to be challenged by filing suit before a
They do not
competent
say
court.
it is void. They say that it is confined only to 6.5 decimals.
Lordship. But
They do
have,
not say that it is void.
but they have not challenged.
They have not challenged.
They have not challenged the sale deed executed and registered in favor of the plaintiff.
That's right.
And the plaintiff, the mother of the plaintiff is a bona fide purchaser of the land.
आगे पढ़िए please.
Lordship.
In this regard,
In this regard,
I find that DW1
I find that DW1 has stated before the court that the suit land is Dharpadi land having an area of 9 to 10 decimal and the suit land is purchased land of the defendant of 20 decimals of land of western side. In the same way, DW2, 3 and 4 stated that the suit land is share of 20 decimals of land of Mohan Jaiswal, who purchased the land from different sale deeds. Ganadhar Ghosh, Gopal Napit and Ashwini Ghosh also got possession. Dependent witnesses also deposed in their examination in chief that the suit land consists of defendant's angan and well and the defendants are in possession of it. This fact has also been stated by DW1, 2, 3 and 4. While the defendant number 6, who is one of the defendants in the present case, the suit land in Moja, Balrampur, Khata number 20, plot number 239, area 2.5 decimal, and the suit land consists his house and well, which was constructed by him. Before 23 to 26 years ago, and the suit land, plot number 259, was initially belonged to Jagannath Napi, and he has sold land to him and to some other persons. And he purchased the land from Jagannath Napi by the registered sale deed number 1480 dated 9/3/76, area 0.6 and half decimals. We are not disputing this 0.6 and half decimal, which was mutated by him and for which he is paying the rent of. He also deposed before the court that he is in peaceful and uninterrupted possession of the suit land since 1972 on his purchased land. In cross-examination, DW1 admitted that he cannot say about the khata number and plot number of the suit land. He also admitted that he cannot say the area of the suit land, and it can be about 9 to 10 decimals. I find that the DW2 also failed to tell about the khata and plot number of the suit land, and he admitted that the suit land was never measured in front of him. There was a demarcation case, Lordship. He also failed to tell that how many persons purchased the suit land, constructed their house and living in. DW5 stated that he has deposed before the court what he has heard, and there is dispute of 2.5 decimals of land. He also deposed that he cannot say that how much land was purchased by Mohan Jaiswal by a deed. DW2 also admitted in cross-examination that plaintiff Mohan Jaiswal told about the case before 1 month of deposition. He further stated that the present case is filed for 1 kattha of land. He also stated that the suit land is originally purchased by Mohan Jaiswal, and initially it is belonged to Gunadhar Ghosh, and Mohan Jaiswal has purchased the land by 3 deeds, and also from Asmini Ghosh, Gopal Napit, and from Jagannath Ghosh by different deeds. However, he failed to tell about the plot number of the suit land. DW4 admitted before the court that he has no knowledge that his 31/5/1975 62 decimals of land was sold, and the purchaser are in possession of it. He also deposed that Saraswati Devi, wife of Deepti Singh, had purchased how much area of the land, how much area of the suit land, and he also admitted that in how much area the house and courtyard is situated. He also admitted that he don't know how much area was sold by Jagannath Napit and his son Gopal Napit out of plot number 259. He also admitted that in 1976 he purchased 6.5 decimals of land from Gunadhar Ghosh, which is in his possession. He very specifically admitted that he has no objection for purchase of land by Saraswati Devi. He also admitted that several other purchasers of land of plot number 259 have constructed their houses and living there. From the perusal of the evidence of PW6, I find that the exclusion of the sale deed is not challenged by DW4, but the area mentioned in the sale deed is definitely challenged by the defendant. I further find that there is certain anomalies and contradiction, but in spite of the detailed cross-examination by the plaintiff, there is nothing to disbelieve DWs. Now I further find that it is again the basic case of the plaintiff that Saraswati Devi, wife of Deepti Singh and mother of the plaintiff, acquired purchased portion of plot number 259 measuring an area of 9 decimals from khata number 20 from the rayat and previous purchaser Gunadhar Ghosh by registered sale deed dated 10/1/1982, and since out of 64 decimal.
You can just come to the finding paragraph. The
From page-
Khatiyan was exhibited,
No, no, sir.
which is a certified copy. Exhibit D is the Khatiyan. Exhibit D is the Khatiyan of plot number 258 and 259.
Certified copy of Khatiyan of
Exhibit D
Khata
निकालिए
number
जरा
20.
समीर जी
exhibit.
इसमें से exhibit D निकालिए. Finding is that the plaintiff could not prove that there was total area of 64.
64 days. This is the finding. And that has, this finding has been Miller affirmed by the learned person.
Exhibit D.
It has been mentioned, Lordship, in the remarks column of the record of right. Lordship may kindly see. Makan 4 decimal, land is Miller 64 decimal. Remarks column, Lordship may kindly see.
258 and 259.
250 and 250.
Rasta, then Dakshin, Mahadev.
No, Lordship. 259, it has been mentioned that Lordship may kindly see Rakba 64 decimals.
That was 64 days.
Lordship.
So area of this entire area is 64 days.
60.
There is no doubt.
No, no, Lordship. 64.
So therefore the learned trial court, by holding that plaintiff has not been proved that Jagannath sold 62 decimal of land from 64 decimal of land.
Now, Lordship may kindly see, my lord, the written statement filed by the defendant. Only 2 paragraphs.
That was the correct. Which paragraph are you referring to?
The plaintiff, my lord, has stated in para 5 regarding the transfer of land by Jagannath Napit, Lordship.
Yes.
And Lordship may kindly see the reply which has been given in para 13 of the written
Para
statement.
11 भी देखिए.
Ji. Parallel. That the statement of para 3 and 4 of the plaint are denied. It is submitted that Gunadhar Ghosh never sold and could not have sold an area of 9 decimals to the plaintiff's mother, as he himself was in possession of only 0.6 and half decimals in plot number 259 of Khata number 20 of village Balrampur, which he acquired by purchase in 1973. Consequently, the plaintiff mother never possessed an area of 9 decimals on the basis of alleged sale deed. Now, Lordship may kindly see para 13. That the statement made in para 5 of the plaint are denied. It is, however, true that Jagannath Napit and his son Gopal Napit had sold some lands to Ganadhar Ghosh and Ashwini Ghosh. Gopal Napit, further while in possession of his unsold land, had transferred an area of 0.7 and half decimals of land to the answering defendant by registered sale deed number 2813 dated 6/6/1992 on receipt of the due consideration and delivered possession. The rest of the contention of the plaintiff in the paragraph under reference are denied and the plaintiff is called upon to prove their claim and statement by cogent evidence. 14 Lordship mechanism. That to be more specific, the defendant submit that Jagannath Napit had transferred an area of 0.6 and half decimals of land to Ganadhar Bose in 1973 and delivered the same to the purchaser with measurement by enemy. Then Lordship paragraph 15 that Ganadhar Bose further purchased an area of 13 decimals. It has been admitted below in the written statement that Ganadhar Bose further purchased an area of 13 decimals in plot number 259 from Gopal Napit by registered sale deed dated 31/5/1975. Thus, Gunadhar was in possession of an area of 0.19 and half decimal of land, out of which he had sold an area of 0.06 and half decimal to the answering defendant by registered sale deed on 9/3/1976. We have purchased 9 decimals, they have purchased 6 and half. Total land acquired by Gunadhar is 13 decimals, 19 decimals. Even if the case of the defendant is accepted, it will become clear that Ganadhar Ghosh has purchased 19 decimals of land and we have purchased only 9 decimals and they have purchased 6 and half.
No, they, as per their deed, they have purchased 9 decimals. They have not purchased 6.5. As per their deed, they have purchased 9 decimals. Now the point is that if you are questioning
As per the deed, they have purchased
9 decimals.
6 and half.
No. As per the deed, it is 9 decimals.
Plaintiff has purchased 9.
Yes, plaintiff has purchased 9.
Lordship, plaintiff has purchased 9.
Plaintiff has purchased 9, but your contention is he purchased only 6.5 decimals.
6 and half.
So how do you say this?
Defendant purchased.
No,
They purchased 6
no,
and
you
half.
say that although the deed was for 9 decimal, but they were in possession of only 6 decimal, 6.5 decimal.
No.
That is your case.
This is the case of the defendant.
Yes, that is
Lordship.
the case of the
This
defendant.
is the case of the defendant.
Yes, but they never challenged that deed of 19
Lordship. This is the case.
at any point of time.
At any point.
They have challenged it only for the first time in the written state.
Written.
Questioning the area covered,
Area covered.
actual area covered by
Lordship. My sale deed was never under challenge. And the plaintiff is continuing in possession. My name has been mutated below on the basis of sale deed which was executed and registered in the year 1980. And we are only concerned with the relief for declaration of title and recovery of possession and confirmation of possession. We are continuing in possession.
What is the finding on possession?
Lordship may kindly see para 28 and 29 of the trial court judgment. No finding has been recorded regarding possession of either of the parties.
specific issue framed on possession?
No.
Is there any direction for suit was dismissed? Okay. So let us come back to the substantial question of law once again.
Lost. Initially, Lord, substantial question of law was framed by the Honorable Court on 6/2/2025. Whether both the learned courts below are not considering that when the defendants have admitted the sale deed executed by Gunadhar was in favor of the plaintiff, and further admitted that original Rayyat, Jagannath Napit and his son Gopal Napit had sold some of plots of land to Gunadhar Ghosh, and further came with a defense that Gunadhar Ghosh did not have possession of 9 decimals of land, rather only 6.5 decimals. Then onus of proving of such facts lies with the defendant. Now, Lordship may kindly see the additional substantial question of law which has been framed below. Whether both the learned courts erred in not considering the admitted case of the defendant. Gunadhar Ghosh had 13 decimals of land left after he sold 6.5 decimals of land to defendant out of 19.5 decimals, and further when plaintiffs proved their possession over 9 decimals of land by way of mutation and also exhibited the rent receipts, plaintiffs were successful in proving their right title interest over the suit land. Now, Lordship may kindly see the judgment of the Honorable Apex Court.
The measurement of Amin in connection with the deed of Gunadhar Ghosh in 1973, has it been exhibited? Measurement of Amin? Has it been exhibited?
No.
Measurement of Amin?
No.
Which you had claimed?
No.
That there was a measurement of
No.
Amin
Yes.
also in connection with 1973
Yes,
deed.
it was their case.
No, it was your case.
So,
You are the defendant. Read your para number 14. In order to substantiate that only 6.5 decimal of land was sold, but not 9 decimal, you stated that there was a measurement by Amin also. Para 14.
with regard to this 1973 position.
Certainly.
73.
You said, see, prima facie there is a sale deed, right? You do not question the sale deed. You do not challenge the sale deed, right? Sale deed can be challenged on many grounds. That the area is incorrect, the boundary is incorrect, right? There is no consideration. There are so many grounds on which the sale deed can be challenged. But you did not challenge that sale deed. And then, while questioning the sale deed with respect to the area, you referred to some report of Amin. The moment the sale deed is not under challenge.
The report here we only stated about delivered possession of the same to the purchaser with measurement by Amin.
Yes. So where is this measurement by Amin?
1973 did. They did not challenge. They challenged the 1992 deed.
You see, 1973 deed. Why will they challenge 1973 deed? 73 deed is their back-to-back sale deed.
Yes.
Why will they challenge it? 73 deed is the deed of back-to-back of Schedule A property.
So 73,
They are relying on 73.
73 is not in dispute so far as 73 our purchase is concerned. They are challenging. We have 3 cell deeds. They challenged
Your date of purchase is
73, 92, 94. So they-
73. How much did you purchase?
6 decimals, 6.
6 and 6.5.
73, 6.5 decibels. 6.5 decibels.
So, according to your written statement, Gunadhar Ghosh had 19 decimal of land, 19 and a half decimal of land. Even if the 6.5 is taken into consideration.
Yes.
13 plus 6.5.
If I'm allowed, I will place the case so far as our case.
You,
is-
I have heard him enough. You just tell you.
Yes, yes,
You
yes.
just.
Yes, no,
explain
no,
your
no,
case.
just let us, I will just.
Are you sure this Amin report has not been executed?
No, it is not. Not it. They have referred to one Amin report so far as they are coming to their cause of action. They have not referred to show that. Now the crux of the matter is concerned.
Now let us. We'll come to that. Is there any dispute that the total area of the land of that particular khata number or plot number was 64 decimal?
No, that is not in dispute.
That is not. Let me just note it down. Total area 64 decimal, not in decimal. Okay.
Now it is their case that they purchased 9 decibels of land, and it is their further case so far as cause of action that so far their 9 decibels they say on the eastern side we did not demarcate on a bounded it was open, and now their cause of action that in the open space the scheduled land should be schedule B, that is suit land. They say that schedule B of the suit land is part of their 9 decimals of land. This is their pleading, this is their assertion that we purchased 9 decimals and the schedule B suit land is part of that 9 decimals and we are trying to grab that schedule B land. On this assertion they filed the claim. Now it was their burden, the burden was on them in terms of section 101 to prove first of all that the schedule B, that is the suit land, is part and parcel of their purchased land, number 1. And that land is included within their registered sale, within the portion of their registered sale. Then only a dispute could have been properly considered. Now, their right title interest by the sale deed by which they purchased 9 decimals 1982, that has been upheld. The court also says yes, there is a 9 decimal sale deed is there. Now the only controversy was that with regard to that portion of the land which they say this is part of our sale deed, but they failed to prove that it is part of their sale deed.
No, they are not able to prove that
No,
because
there is no finding, there is no evidence.
they
Let them.
have produced a mutation also.
Now mutation is of 9 decibels.
Yes,
9
mutation
decibels.
is of
Then
9
the
decibels.
dispute is.
The sale deed also has a boundary.
No, they say one side it
The
was.
sale deed is also a boundary.
Boundary.
Maybe you see the sale deed had a boundary. Maybe that they did not demarcate it by erecting a wall.
Yes.
But sale deed had a boundary.
But the only issue is that whether these 9 decimals or whether the land which has been mutated in their favor, that includes the suit land. Suit land is schedule B. There is no such evidence by them on that point. No evidence on that point. That is the crux of the matter. Let them show that there is a evidence on that point. Undisputed evidence or unimpeachable evidence that what we have purchased, it also includes schedule B. Because their basic cause of action is that we are trying to grab their land which is schedule B, not their entire land, they say schedule B. Their plaint is concerned.
The tissue paper tag.
please para 14 of their claim. We should show that what was the basis of their case. The assertion made. Para 14 internal.
You refer to your written statement.
I will refer to that, but first of all, because they have filed the suit, the burden was on them to prove. They cannot rely upon any of our weakness, or first of all, they have the primary burden is on them to show. Because our registered cell leads are there, those have been found to be proper. There is nothing has been found that our cell leads are forged or it was executed without authority. Nothing such has been found. So first of all, if para 14 of their plaintiff is saying, and one thing is very important before going to para 14, their assertion in para 5 about all the transfers, we have not admitted it. As it was contended on behalf of the appellant that we have admitted, we have denied that para 5. We have only admitted so far as the transactions to the extent of the registered cell leads. So far we are concerned or the plaintiffs are concerned. So far the other cell leads which they refer, there is no admission. And they have not brought on record those cell leads to show that 62 out of 64 decimals of the land has been sold. Now if I am allowed to read para 14, page 7, para 14 of their claim. That it may be submitted that as because the defendant was laying false claim over the open area on the eastern part of the purchased land of late Saraswati Devi. Saraswati Devi is plaintiff's mother, measuring 9 decimals over which an well was dug, and the same has been coming under the use of the plaintiff since the time it was dug, and eastern part open land measuring 66 into 17 feet, somewhere on the sum area it may be by 15 feet by breadth. This is the suit land which is the described schedule B, page 8. The defendant has been keeping a greedy eye over the said open space, the part and parcel of the purchased land. The part and parcel of the purchased land of the Saraswati Devi. Now these things, they have not proved at all that this schedule B is part and parcel of their purchased land or schedule A land. Then para 50, that for the unscrupulous and illegal baseless claim of the defendant, the husband of Saraswati Devi, namely Dipti Singh, had to file a petition before the Anchal Adhikari Gavaria. Para 15, the case which they were trying to settle. The said petition was entertained by Anchal Adhikari and demarcation case number 58/2006 was registered. The Anchal Adhikari got the report and found that the said land of Mauja so and so, Khata so and so, plot 259, area 9 decimal has been mutated and rent have been paid. Accordingly, the Anchal Adhikari directed to pay the cost for demarcation. The Anchal measured the said area 9 decimal and area of 9 decimal was demarcated in presence of local people by the who prepared the map, and government submitted his report that on, this report is not on report, it is their case, that on 8/1/2007 he measured the area of 9 decimal of Saraswati Devi versus Mohan Jaiswal. He reported that he measured the land of Saraswati Devi and demarcated the area 9 decimal, and he also found in fact the land of Mohan Jaiswal was only 15 decimal. This was their case. Though the claim of Mohan Jaiswal is much more land, the said Gautam Hajra after demarcation has reported that unless registered to is duly verified, Mohan Jaiswal should maintain and the said measurement should be.
Mr. Banerjee, just one. Once you say that under the sale deed by which the plaintiffs have purchased the property, the area which was handed over to the plaintiff was only 6.5 decimal. It is not your case in the written statement that Schedule B property is not a part of Schedule A property. That is not your case.
No,
Say
it is their case. It is their case.
No.
We
Just a moment.
leave aside written statement. We
No,
assume that we have not
you
filed
see,
anything.
unless anything which is not denied in the written statement stands admitted.
Yes, but even assuming.
It is not your case in your written statement that this particular, you say that this particular Schedule B property cannot be said to be theirs because they actually got possession of 6.5.
We are not saying anything.
Yes, this is
No,
what your
just
case is.
for a moment, for the sake of argument, we assume that we did not file any written.
No, we will not assume that.
No, for a
Mr.
moment.
Banerjee, we will not assume that.
First, let us see what is their case because of plaintiff.
What do you want to say? That they will have to stand on their own legs?
Yes,
Right.
yes.
Okay, let us see.
That
But
is-
once a written statement has been filed
Yes.
and certain things stands admitted, We will not check.
What has been admitted?
Admitted facts need not be proved.
Then first I am reading
As simple as that.
para 15. Para 15, then I will show what is the principles of admission. Section 15 to be read with order 825. If para 15 is same, what case they have set up in the plaint, their cause of action. Para 14 I have shown that their specific assertion that Schedule B is part of Schedule A. Then para 15 they are narrating about the demarcation made. I was just reading internal page 9. And he was found in Mohan Jaswal 15th, though the claim of Mohan Jaswal much more. The said Amin Gautam Hazara demarcation reported that unless registered is verified, should maintain and the same measurement should be maintained by parties. Furthermore, it will be material to note in the said report that Saraswati Devi purchased land by sale deed number 4080 dated 10/11/82, which was mutated in mutation case number 280/87/88. The rent is being paid and actual area of 9 decimal was demarcated. Whereas as per Mohan Jaswal, his purchased land 20 decimal are not available in plot 259 and only 15 decimal of land was found in actual possession of Mohan Jaswal, the defendant. The same is quite natural for the facts stated above. That these two foundational fact 14-15, then that since the eastern part of the plaintiff's land are lying open, the defendant with other great and with ulterior motive caused to start a proceeding under section 145 pending cess law. Due to misconception, the second party, DT Singh, husband of, was deprived to give evidence and 145 was drawn. So, then para 17, again their case, the defendant has filed another case for an area of 20 decimals of Mauja Suvansu. It is then subpara, it is appearing still the defendant is trying to make up his claim of 20 decimal and want to grab the open space, the suit lands by hook or crook. That is Schedule B land. So, reading para 14, 15 and 17, the purpose was to show that why they filed the suit, what was their case, what was their assertion in the plaint. Their assertion was that they are rightful owner of 9 decimals of land which is described in Schedule A, and their further assertion was that Schedule B is also part and parcel of their purchased land, that is part of Schedule A, and that we are trying to grab that land, and that in course of some demarcation case and measurement report, it was found that we have 15 decimals of land and their land was demarcated. But in support of para 15, no evidence has been given, neither documentary, because they have referred to documents. No such documentary evidence has been given. So far their case is concerned. Now coming to our written statement. Coming to a written statement, if the written statement is seen, paragraph 11.
You are referring to plain para number.
This is para number 14.
You just give it the paragraphs.
Yes, para 14.
Para 14.
15.
15.
And 17.
17.
To show that what was their cause of action and what assertion they made.
Written statement para.
Yes, written statement. I am now referring to para 11. Now, para 3, they say, para 2 they have described suit land, para 3 of land, they say that the land is a part and parcel of plot 259, para 3. We have not admitted this, we have denied. Para 11 we have said that the statement of para 3 and 4 of the plaint are denied. There is no admission so far as this contention is concerned. Had there been any admission on this point, then I may have been difficulty so far as the principles of admission are concerned, even assuming. So this part 3 and 4 the plaint are denied. Then the further statement which is being now relied by the plaintiffs.
No, you read the rest of the portion also.
Yes.
Don't read selectively.
Yes, I am reading entire.
Read entire.
Yes, I first of all have shown that we have stated that para 3 is denied. Yes. So we do not admit that Schedule B is part of Schedule A. Then entire. It is submitted that Gunadhar Ghosh never sold and could not have sold an area of 9 decimals to the plaintiff's mother, as he himself was in possession of only 6.5 decimals in plot 259 of Khata 20, village Balrampur, which he acquired by purchase in 1973. Consequently, the plaintiff's mother never possessed an area of 9 decimals on the basis of the alleged sentence. Then para 12,
contention with regard to the mutation case and the alleged inquiry are false and baseless. The claim of possession by the plaintiff mother in her allegedly purchased land is also incorrect, as no inquiry or measurement on the spot was done by Anchor office. The answering defendant was also never noticed in the said mutation case, and no arms was promoted to said mutation case. Then para 13 is again important because it is reply to para 5. Para 5, there are so many transactions are mentioned, which according to them is of plot 259, all other transactions. But they have not substantiated it. Para 13. Statement made in para 5 of the plaintiff are denied. It is however true that Jagannath Napit and his son Gopal Napit had sold some lands to Gunadhar Ghosh and Ashwini Ghosh. Gunadhar Ghosh and Ashwini Ghosh are our vendors also. We have purchased 2 cell from Gunadhar Ghosh and one cell from Ashwini Ghosh. They are our vendors also.
But all your sale deeds you have not exhibited.
Yes, all 3 are exhibited. B1, B2. All 3 are exhibited. We have exhibited the Khatiyan, we have exhibited our rent receipts, we have exhibited the so far as correction slips. Then we have referred to this because Jagannath Tapis and his son Gopal Napit sold to Gunadhar Ghosh and Ashwini Ghosh. So they are also a vendor. Then subsequently para 13 we say Gopal Napit further while in possession of his land transferred area of 7.5 decibels to answering defendant by registered cell deed 2813 dated 6/6/92. This was challenged by them. Out of 3, this one deed was challenged by them. On receipt of due consideration and delivered possession. We have specifically asserted this. Receipt of due consideration and delivered possession. The rest of the contention of the plaintiff in the paragraph under reference are denied. Then again there is a specific denial. The rest of the contention of the plaintiff in the paragraph under reference are denied, and the plaintiff is called upon to prove their claim and statement by cogent evidence. And what was in para 5? Para 5 contained their assertion that there are so many transactions with respect to plot 259 in order to set up their case that out of 64 decibels, 62 decibels was sold. And so only 2 decibels was left, and therefore there could not have been any further sale. But they have failed to prove that contention, which we have specifically denied, and we have also made an assertion that it is they have to prove, because those sale deeds are not on record, the other sale deeds. Then this was replied to para 5 in our para 13 of our written statement, where we have a specific denial with regard to para 5 or their other contentions. And then para 14 is there. That to be more specific, the defendant submits that Jagannath Napit had transferred an area of 6.5 decibels land to Gunadhar Ghosh in 1973. Gunadhar Ghosh, our vendor also, and delivered the same to the purchaser with measurement by AMI, which was pointed out by the Honorable Court. So these 6.5 decibels, 1973, this was never challenged by them in the entire plaint. Their only challenge is that we are trying to grab their purchased portion of their 9 decibels of land. This is the reason of the case which they are asserting, that we are trying to grab some portion of their 9 decibels of land. So these 6.5 decibels of land purchased by Gunadhar Ghosh and delivered the same to purchaser with measurement by AMI. Gunadhar Ghosh was given possession. Gunadhar Ghosh is our friend. Then para 15 is there. Gunadhar Ghosh further purchased area of 13 decibels in plot 259 from Gopal Napit, son of Jagannath Napit, by registered cell deed dated 31/5/75. Thus, Gunadhar Ghosh was in possession of an area of 19.5 decibels, out of which he sold an area of 6.5 decibels to the answering defendant by registered cell deed number 1480/9376. This cell deed, which we exhibited as Exhibit B, our cell deed. This cell deed is also not in dispute. This has not been challenged by them. The vendor of this cell deed is Gunadhar Ghosh, 9376. So para 15 again asserts our case. For this purpose, we have stated that how our vendor got the land and how much land he was in possession, and he transferred 6.5 decibels to us by this cell deed in the year 1976. then para 16 we have asserted that the answering defendant also purchased an area of 7.5 decimals in plot 259 from Gopal Napi by registered sale date 2813 dated 6/6/92, which is improved, as he was in possession of the same on payment of rent after mutation. We have also asserted about our possession and we have brought on record this correction slip and the rent receipts. The defendants further purchased an area of 6 decimals in plot 259 by registered sale date 3/26/11 from Ashwini Ghosh, as he acquired the same by purchase in 1974 from Gopal Napi. The defendant thus purchased a total area of 20 decimals in plot 259 and possessed the same on payment of rent to the state government after mutation. So this is our case. And now I referred para 15 of their plaint because they are saying, according to them, some Amin found that we were in possession 15 decimals, not 20 decimals. But they could not prove their case, what they asserted. So these admissions does not have a relevancy or bearing so far as the issue in dispute is concerned, because the issue in dispute is basically that the Schedule B, which is the suit land, is part and parcel of Schedule A or not. We have categorically denied that it is not part and parcel. They are asserted in para 3 of the plaint, and there is no evidence on that. So far as para 15, no such demarcation case proceedings, no such Amin report is on record.
Yes, you continue your argument.
Yes.
Don't
Now the relief portion of their plaint, if that is seen, the first relief which they have sought for a declaration that the suit land is the purchased land of plaintiff's mother. That the suit land is the purchased land of plaintiff's mother, meaning thereby that the suit land is part and parcel of Schedule A. This declaration they sought from the court, and the plaintiffs have got a right title interest over the same. This is the relief they wanted. They sought for a declaration that the Schedule B land has been purchased by them. So for this purpose to getting a degree from the competent court of law, that a particular land has been purchased by them, they have to show that the Schedule B land is part and parcel of either of the sale deed which they are relying so far as Schedule A is concerned, or by any other sale deed. But none of the ways they have proved that the 19 Exhibit 2 includes Schedule B, or otherwise no other sale deed has been brought on record to show that Schedule B has been purchased by any other sale deed. And this was their prayer which they sought for. Not with respect to Schedule A, but with respect to Schedule B. And so far as the judgment of the learned first court, this honorable court has already seen, learned friend has read out the paragraph.
Respondent. The learned counsel for the respondent does not dispute that the total area of the land in plot number 259 was 64 decimal. However, he has submitted that the specific case of the plaintiff was that Schedule B is a part of Schedule A property, but no evidence was laid to prove this aspect of the matter. He has also stated that the various pleadings he has referred to the paragraph 14, 15, 17 of the plaint and paragraph 11 of the written statement to submit that it was never admitted by the defendant that Schedule B was a part of Schedule A property. He has also submitted that it was a specific case of the defendant that the land covered under the sale deed number 1480 नहीं under the sale deed number कौन सा sale deed number है आपका 1982
1982 जो
1982
plaintiffs का जो है exhibit 2
executed in favor of the mother of the plaintiffs was only 6.5 decimal, which she was already in possession. Yeah, that was your case, that it was only 6.5 decimal, which she was already in possession.
हाँ हम लोग का जो written statement में जो लिखा हुआ है
and the land was not to the extent of 9 decimal. Right?
11 में हम लोग जो लिखे हैं it is submitted that जो language है para 11 written statement that Gunadhar Bose never sold and could not have sold an area of 9 decimal to the plaintiff's mother as he himself was in possession of only 6.5 decimals in plot 259 of Kata 20 which he acquired by purchaser in 1973. Consequently, the plaintiff's mother never possessed an area of 9 decimals on the basis of the alleged sale deed.
He has also submitted that the vendor of the mother of plaintiff had also acquired only 6 decimal of land and not 9 decimal of land. The learned counsel has submitted that the sale deed of the vendor of the plaintiff was not executed before the court. To ascertain as to how much property was sold to Gunadhar Gop in the year 1970. That's all. You want to say anything on substantial question?
Yes, on the first one more thing which I argued on this so far as relief sought for by them. They have sought for a relief with regard to declaration that the suit land is purchased land of plaintiffs. This is the for a declaration that the suit land is the purchased land of plaintiff's mother, and so the plaintiff have got a right title interest. So this, for the purpose of this declaration, getting this declaration, they have to show that Schedule B land is purchased by some sale deed, either by Exhibit 2 or by some other sale deed. And they have failed to prove that this Schedule B has been purchased, has also been purchased or is part of Exhibit 2.
This
The learned counsel submits that the plaintiff had sought a declaration that the Schedule A property was their purchased property. Right?
नहीं, Schedule B. Schedule B is the suit land,
Schedule
B,
Schedule B property, just
which is the suit land.
just
Page 13 of the plan.
has submitted that the plaintiff had sought a declaration that the suit land is purchased land of the plaintiff's mother, and the plaintiff had got right title and interest over the same. This is referring to Schedule A property.
No.
Yes.
No, Schedule B. Just come to the next page.
आप A देखिए ना, A is purchased land of plaintiff's
नहीं नहीं, अब
mother.
ये डिक्लेरेशन क्या वही तुम दिखाना चाह रहे हैं. फॉर अ डिक्लेरेशन दैट द सूट लैंड क्या है, नेक्स्ट पे जाएंगे. शेड्यूल में सूट लैंड लोग किसको रेफर कर रहे हैं, शेड्यूल बी को सूट लैंड रेफर कर रहे हैं, नॉट शेड्यूल ए.
अच्छा.
देयरफॉर आई एम सबमिटिंग दिस.
And
शेड्यूल बी के नीचे सूट लैंड स्पेसिफिकली लिखे दिए.
the suit land was referable to Schedule B of the plaint. The learned counsel submits that it was for the plaintiff to demonstrate that Schedule B was a part of Schedule A property, which the plaintiffs have failed to demonstrate. It is also submitted that the plaintiff, having failed to demonstrate that Schedule B was a part of Schedule A property, the suit was rightly dismissed.
And then further, so far as 64 decimals.
देखिए, I'll tell you, Mr. Banerjee, I'm listening to you. आप सीधे आप substantial question of law में आपका
हाँ,
सारा
नहीं,
कहानी सुन लिया.
नहीं, एक जो
अब
इम्पोर्टेंट
आप क्या है कि देखिए एक एक करके नहीं, आपका कितना important aspect है और है बता दीजिए. Give me in number. क्योंकि after completing one, then you will say there is one more important aspect. आप बताइए how many important aspects are left to be argued by you apart from the substantial question of law.
one is left, one is very significant for the purpose of deciding the substantial question of law.
One
also.
is left. Okay.
Yes.
You come.
One
you
is
come
left.
to that.
Now Khata 259 that has 64 decimals of land, that is undisputed.
Then don't repeat that.
Yes, no, then I'm coming to the point. Now it is their case in the plaint that 62 decimals out of 64 decimals has been sold in order to assail our 1992 sale rate. Now on that aspect, they have failed to prove that 62 decimals of plot 259 was sold. And in this regard, I would refer to the findings also at page 28 of the learned first running page 24, paragraph 28.
Yes.
From perusal of both ocular testimony of both sides and documentary evidences of both the sides,
The learned counsel for the respondent has referred to paragraph 28 of the trial court's judgment and has submitted that it was a specific case of the plaintiff that 62 decimal out of 64 decimal was already sold, but they have failed to prove. He submits that this was the foundational fact to challenge the sale deed involved in this case. It was under challenge in this.
because
What
because there is a categorical finding, plaintiff not able to produce and exhibit different sale rates by which it would have been proved that 62 decimals land was sold to different persons and only 62 decimal remain unsold. And this is also not a admitted fact in the written statement. Now
The learned counsel submits that in the written statement, it is not an admitted fact that 62 decimal out of 64 decimal was sold.
yes, which is
As claimed by the plaintiff.
yes, which
He
is
has submitted that the sale deeds by which the 62 decimal was said to have been sold were not exhibited before the court, and therefore this fact was not.
and this our contention is has been asserted in para 13 of our
That's
document.
why contention is okay.
Now coming to the substantive questions of law. The first question, which was originally framed, whether both the learned courts below erred in not considering that when defendants have admitted the sale deed executed by Gunadhar Ghosh in favor of plaintiffs. First part is that we have admitted sale deed executed by Gunadhar Ghosh in favor of plaintiffs. and further admitted that original Rayat had sold some plot of land to Gunadhar Ghosh. And further came with the defense that Gunadhar Ghosh did not have possession of 9 decimals of land, rather only 6.5 decimals, when owners of proving such fact was with the defendants. Now, coming to the, so far as burden of proof is concerned, owners may shift, burden never shifts. Now, these facts we stated, they are stated. The first part of this substantial question of law refers to Exhibit 2. Exhibit 2 stands, the learned first court has said, yes, there is a sale deed in their favor, 9 decimals, no dispute. The dispute was whether 9 decimals covers Schedule B, the suit line. Thus, dispute was there, on which they could not adduce any evidence. So, first part of this question of law, and in conjointly, my submission would be that our admission to the extent of that there are 9 decimals of land does not absolve them from proving their assertion.
Your admission was not that. Your admission was execution of the sale deed was admitted,
Yes.
and your admission was only to the extent of 6.5 decimals.
Execution of sale deed.
Execution of sale deed was not in dispute,
Yes.
but your specific case was that it was only in relation to 6.5
6.5 decimals. Even so far as that part is concerned, we failed to discharge our burden. So far that part is concerned. Then also, the plaintiff's case is not established from our said admission, because that said admission is not concerned with the plaintiff's case, because the plaintiff's case is that some portion of 9 decimals of land, which is in their possession, which we are trying to grab, that is part of that 9 decimals of land. This admission in any manner does not prove that the 9 decimals sale deed includes Schedule B. That is our reply to this.
With respect to the first substantial question of law framed by this court by order dated 6/2/2025, the learned counsel has submitted that though the sale deed Exhibit 2 executed in favor of the mother of the plaintiffs was admitted, but there was a dispute that the same was not in connection with 9 decimals of land, but it was only in connection with 6.5 decimals of land, which was the area which was handed over pursuant to the sale deed. He submits that the same admission by the defendant with regard to execution of sale deed, but qualified by the fact that it was only in connection with 6.5 decimals of land, does not help the plaintiffs in any manner, as the plaintiffs have failed to prove that Schedule B is a part of Schedule A property. Second substantial
Yes,
question
the
of law.
second question is that whether both the learned courts erred in not considering the admitted case of defendants that Gunadhar Ghosh was left with 13 decimals of land out of his total land of 19.5 decimals after he sold 6.5 decimals to defendants, and further when plaintiff proved their possession over 9 decimals of land purchased from Gunadhar Ghosh by way of registered sale deed, mutation rent receipt, plaintiffs were succeeding in proving their right title interest over the suit land. Now again, this is somewhat related to the first question of law. Their plaintiffs contention has been accepted by the first court so far as their registered sale deed that has been appealed. I will just refer to that specific line for a moment where it has been appealed.
internal page 13 bottom.
J. There are that he has no purchase of, he has very admitted that he has no objection purchase land, he has also admitted several so and so. And here, admitted 76 he purchased so and so. I find there is
From the perusal of the evidence of PW6, I find that the execution of the sale deed is not under challenge by either groups.
Yes. These are was trying to swear.
But the area mentioned in the sale deed is definitely challenged by.
Definitely, yes. So far as this second question of law is concerned, now this second question of law with regard to that the courts, the learned courts have, whether the learned courts have erred in not declaring their right title interest. So the learned courts have very well declared their right title interest so far as their purchased land of 9 decimals is concerned. There is no error in that. They have declared because we did not challenge it. They have brought on record the registered sale deed. That could not be impeached. That has been declared. But even then, even if that question of law is decided in their favor, it does not absolves them from proving their case that the right title interest which they sought for, that was for the suit land, not for the entire purchased land. They did not sought for right title interest for Schedule A land, but they sought for Schedule B. And for Schedule B, the courts below have not committed any error. For Schedule A, courts below have not, it has, because no such decree was sought for. So it is a finding has been recorded, and it is not a basic operating portion of the order.
The learned counsel for the respondents, while referring to the second substantial question of law, has submitted that the learned trial court has recorded a finding at internal page 13 that the execution of sale deed covering execution of sale deed in the name of mother of the plaintiffs in the year 1982 was not challenged by the defendants, but the area mentioned in the sale deed was under challenge. He submits that the sale deed exhibit 2 of 9 decimal read with the rent receipts and mutation orders certainly prove that the plaintiff's mother had purchased 9 decimal of land and got the same mutated. But this does not help the appellant in any manner, inasmuch as they have failed to prove that Schedule B of the property was a part of Schedule A property. He submits that the suit property was only Schedule B property and not Schedule A property. And therefore, even if substantial question of law number 2 is answered in favor of the appellant, the same has no bearing in this case.
As because the declaration is sought for in respect of Schedule B and not
ऊपर
Schedule
लिखा दिए ना? That's all.
some judgments.
Which judgment do you want to refer to?
Yes. I'm giving the copies. 2017, volume 9, SCC. That is page 586.
Para number?
Para 15 and 16 would be relevant for our purpose, so far as burden of proof is concerned. Page 589. 589, para 16.
You have cited 15 and 16.
15 is
You
also.
read 15 also.
It is more so when these findings are neither. Because in our case also findings are neither pleading nor evidence, nor against evidence and nor contrary to any provision of law. They are also not perverse to the extent that no such finding could ever be reported by any judicial person. In other words, unless the findings of facts, though concurrent, like here, are found to be extremely perverse, so as to affect the judicial conscience of a judge, they would be binding on the appellate. And then para 16, 15 matches with our fact. Para 16, it is a settled principle of law that initial burden is always on the plaintiff to prove his case by proper pleading and adequate evidence, oral and documentary support thereof. Plaintiff in this case could not prove with any documentary evidence, so much that much is.
अब आधा नहीं पढ़ा.
The plaintiffs in this case could not prove with any documentary evidence that the suit properties described in Schedule B and C were their self-acquired properties, and the partition did not take place in respect of Schedule D properties, and it continued to remain ancestral in the hand of family members. On the other hand, the defendants were able to prove that the partition took place and was acted upon, because his matter in hand was arising out of partition. So basic principles are there. So far as 15 is concerned, it is with regard to the consideration of the pleadings and when it can be interfered if it is found to be extremely perverse. And 16 is with regard to the initial burden of proof.
You see, once a substantial question of law is framed, everything is open. Everything is open.
Yes.
So that has to be answered.
Yes, we have answered the substantial question of law on the given facts. On the given facts, but the broader principles are like this. The broader principles are like this.
Okay, para 15 and 16. Is there any other?
Yes.
To submit that, unless the finding of fact, though concurrent, are found to be extremely perverse, so as to affect the judicial conscience of the judge, they would be binding on the appellate court. And has further submitted that the initial burden is always on the plaintiff to prove his case by proper pleadings and adequate evidence, oral and documentary, in support thereof. He submits that though the aforesaid judgment was arising out of a partition suit, but the principles of law would apply in the present case also. Next judgment.
Yes. That is 2004, volume 7 SCC, page 708.
2004, volume 7, SCC 708, para number.
Para number 8. That is at page 715. Last page. As is evident, the High Court took into consideration the written statement filed by the Secretary Work Board, wherein it is stated that the plaintiff committee was very irregular in submitting annual statement of account to the Work Board, and in payment of annual contribution to the board as per provision of the Act in support of the view, the plaintiff was actually acting as a mutawali. This approach in our view was not correct. The written statement filed by the Work Board could not bind defendant number 2. Further, any statement made in the said written statement could not be accepted against defendant number 2 unless it was established on the basis of evidence. Unless it was established on the basis of evidence, the decision of Mohiduddin Bibi Anwar in our view does not help the plaintiff to apply the said decision. Necessary facts ought to have been pleaded and established. In the case on hand, as already noticed, neither there was a pleading specifically in the plaint as to the plaintiff actually taking as mutawali to come within scope of section 3F of the 1954 Work Act, nor was acceptable and sufficient evidence placed on record to prove it as a fact. In the situation, the aforementioned decision has no application to the case of plaintiff. When the plaintiff came forward specifically pleading that he was entitled to declaration of title and for recovery of possession of the plaintiff's ceded property based on the agreement, Exhibit A2 dated 13/2/73, it could succeed only on the basis of validity of Exhibit 2 and the validity of transfer of mutuality in its favor. Since all the courts have concurrently found that mutuality could not be validly transferred in favor of plaintiff, the suit filed the plaintiff ought to have been dismissed. The plaintiff could not succeed on the strength of its case. The plaintiff could only succeed on the strength of its case and not on the weakness found in the case of the defendant, if any. The first appellate court having elaborately considered the evidence placed on record in the light of the pleadings of the parties had come to the right conclusion in dismissing the suit of the plaintiff. The High Court in our second appeal view was not right in upsetting the findings of fact recorded by the first appellate court, that too without putting on the question of law. Otherwise, the finding of High Court on question 3 cannot
नहीं
be.
नहीं आधा सेंटेंस मत पढ़ा करके
The High Court in second
please
appellate.
never read it
हाँ.
because I read the full sentence and the full
The
paragraph.
first appellate court having elaborately considered the evidence placed on record in the light of the pleadings of the parties had come to the right conclusion in dismissing the suit of the plaintiff. The High Court in second appeal in our view was not right in upsetting the findings of fact recorded by the first appellate court, that too without putting the parties on notice on the substantial question of law. Even otherwise, the finding of the High Court on question 3 cannot be sustained when such a case did not arise for consideration in the absence of necessary pleading in the plaint in that regard. More so when the case of the plaintiff was based clearly on titles said to have been derived under Exhibit 8. So
What
this,
do you want to submit by referring to this?
from this, that whatever has been asserted, whatever has been pleaded, that has to be proved. Moreover, so far as any averment made in the written statement cannot bind the defendant, and it cannot be taken against the defendant unless it is proved. Unless it is
Well,
proved.
let it counsel for the respondent by referring to the judgment passed by the Honorable Supreme Court reported in bracket 2004 bracket 47 SCC 708 para 8 has submitted that any statement made in the written statement cannot be used unless it is duly proved. He has submitted that in the written statement certain averments have been made in the present case, but the same has not been proved, and therefore those statements are of no consequence in the matter of deciding the substantial questions of law involved in this case. Upon perusal of para 8, it appears that the written statement was filed by Waqf Board. No, written statement filed by, it was observed that the written statement filed by Waqf Board could not bind the defendant number 2. And in order to bind defendant number 2, the statement made in the written statement filed by Waqf Board was required to be established on the basis of evidence. Co-defendant को नहीं bind करेगा, उसको कैसे नहीं bind करेगा, ये तो बहुत अजीब बात है.
और ये है ना कि unless established on the basis.
That's it. Co-defendant को नहीं bind करेगा.
This is on my alternative plea because I have already answered the question of law that even assuming that my admission is there, it does not absolve them from their primary burden of discharging. This is alternatively on point of admission.
That's all.
There is one mere assertion in plaint.
Those things are not substantial question of law. ऐसे तो क्या है ना कि you can just go on.
Because we can answer
This judgment also has no relevance because this particular judgment is referring to admission of a co-defendant.
And further, this says that it cannot be decided on something which is on the weakness of the defendants. This says weakness of the defendants.
That law you have already said
Yes,
in the other judgment.
Yes, because we can answer the question of law, substantial question of law, only going to the facts, all the attending facts.
Certainly.
Otherwise, we cannot answer it, because even if the question and substantial questions are answered in peculiar facts of this case, then also their relief sought for may not be
We
decreed.
will see what is the consequence of the substantial question of law.
That is
because consequence has to be dealt with by the second appellate court itself.
And this 2012-5 was only saying because as I read paragraph 14, 15 and 17 of the appellant, that they asserted their cause of action. That they got some demarcation case, they got measured, they found our land less, but that was not proof. It is a mere assertion. And so it has.
There is no finding also to that.
Yes, there is no finding.
There is no finding, so we don't need to worry about it.
Therefore, the findings are not at fault. The findings are perfect.
Findings are not on the basis of those assertions.
Yes, there is not on
because there is no evidence to that effect. The court has not gone by the mere assertions in the plaint. Court has not gone
The court
by
has
that.
not done. Therefore, to defend those findings, I say that the court has rightly proceeded because I am here. I am defending the judgments. Court
That's
has,
it. It's okay. हाँ आपको क्या बोलना है?
By way of reply, Lordship may kindly see.
What is the area of Schedule B property?
Lordship may kindly see.
You just give me the exact calculation. How much will it come to?
Area, my lord, it has been mentioned in Schedule B.
In terms of decimal, how much will it be there? It is in terms of square feet.
Square feet. Is that what, Lordship?
It's a gully, right?
Lordship, 66 feet into 17 feet. And in some part, 15.
66 into 17. Let's take it 66. Some part it is 15.
15.
How much is 66 into 17 feet? Calculate करिए तो. 66 into 17. And how much square feet is one kattha? One decimal? 1122 square feet. How much is one decimal?
One katta is about 720.
720 square feet.
So far
Lordship.
as short calculation.
720 square feet.
720.
Okay.
अब बताइए आपको रिजॉइंटर में क्या बोलना है?
Lordship may kindly see para 18 of the claim. It
अब
has
आप
been
किस प्लेट में आ रहे
no khali
Para 18 has been denied.
denied, but Lordship may kindly see the evidence. Evidence of DW, PW का भी दिखा. इनका केस है कि it has not been proved that
It has
Schedule
not
B.
been proved that Schedule B is a part of
Lordship may kindly see the evidence of PW and DW.
Which PW are you taking?
Lordship.
You just give me the witness number and para.
PW number 5,
PW 5, para number
para number 39,
39. Okay. And और कौन सा witness आप रखे?
or they रहते DW,
DW
DW1,
1, para number
para 26 and 30.
26 and 30. काफी है?
बस.
पढ़ी para काफी है. ये दीजिए जरा PW 5.
PW5 का para 39. Specific pleading है para 18 में. Schedule B is the part of Schedule A property.
Yes.
It has been proved by PW5. Lordship may kindly see para 39. ऐसी बात नहीं है कि विवादित जमीन मेरी खरीदी हुई जमीन का अंश नहीं है, बल्कि प्रतिवादी की खरीदगी हुई जमीन का अंश. There is a specific Lordship, PW5 has stated that it is part of Schedule A, and now Lordship may kindly see the evidence of DW. DW1,
Just a moment.
Lordship.
और DW?
DW का हुजूर देखा जाएगा। DW1 पैरा 22
अभी आप 26 and 30 बोले थे
26 I'm sorry पैरा 26
पैरा 26
डिप्टी सिंह लॉर्डशिप
हाँ
डिप्टी सिंह he is the husband of सरस्वती देवी।
हम्म,
डिप्टी सिंह ने अपनी पत्नी के नाम से गुनाधर घोष से खरीदा है। उसका रकबा 9 डिसमिल जिसे वह बराबर घर बनाकर कब्जा करते आ रहे हैं। नाउ लॉर्डशिप में कहीं इसी पैरा 30 मुझे इस बात की जानकारी है कि यह केस 66 फीट इंटू 17 फीट जमीन के लिए चल रहा है जो डिप्टी सिंह के आंगनबाड़ी से सटा है जिसमें उत्तर प्रभु पटेल दक्षिण सरकार पूरब प्रतिवादी तथा पश्चिम वादी का घर है। पूरब में प्रतिवादी की 20 डिसमिल जमीन they themselves have admitted
they are claiming 22 decimal of land.
20 decimals
20 decimals.
20 decimals
पैरा 33 भी पढ़िए।
Plus. ऐसी बात नहीं है कि विवादित जमीन डिप्टी सिंह की जमीन का अंश है तथा कुआं को डिप्टी सिंह ने बनाया।
उसका तो एविडेंस कॉन्फ्लिक्टिंग है। इस DW का एविडेंस कॉन्फ्लिक्टिंग है।
कॉन्फ्लिक्टिंग है लेकिन पैरा 30 में हुजूर
30
स्पेसिफिक
देखने और 33 ना देखने। एविडेंस हैज टू बी रेड एज अ होल।
नहीं ठीक है
एक लाइन देख के नहीं बोलना।
33 भी देखा जाए ऐसी बात नहीं है कि विवादित जमीन डिप्टी सिंह की जमीन का अंश है तथा कुआं को डिप्टी सिंह ने बनाया।
इसको नहीं देख सकते ऐसे।
प्लेंटिफ का हुजूर एविडेंस है स्पेसिफिक एविडेंस है Schedule B land is part of Schedule A property which has been purchased by the mother of the plaintiff by registered sale deed in the year 19.
The learned counsel for the appellant in response has referred to the evidence of PW5. Who is the plaintiff? Who is the plaintiff of the case? And submits that he in his evidence has clearly stated that Schedule B is a part of Schedule A property. And during his cross-examination in paragraph 39, has stated that it is not correct to say that the disputed land is not a part of the property purchased by his mother. He has also referred to paragraph 18 of the plate. That's it. कुछ बोलना नहीं है ना किसी को? ओवर.
हाँ सर, फैक्ट्स क्लियर हो गए सारे.
Arguments concluded. Post for dictation day after tomorrow. उस दिन कुछ भी मत बोलिएगा, हम सुनेंगे नहीं एक भी लाइन.
अभी से क्यों प्रिज्यूम कर रहे हैं?
हम
बोले.
प्रिज्यूम
लोग
करते
बोलते
हैं
ना,
क्योंकि जब हम डिक्टेशन देने लगते हैं तो आप लोग को कुछ नया नया बात याद आता है. ऐसा नहीं, आप लोग को पूरा सुन लिए.
एडवोकेट रहेंगे तो एडवोकेट तो
नहीं
बोले.
नहीं, एडवोकेट रहेंगे.
अधिवक्ता, अधिक बोलने के लिए अधिक हम लोग का नाम अधिवक्ता पड़ा है.
नहीं, नहीं,
हम लोग कहीं ना कहीं तो बोले.
अधिवक्ता का मतलब अधिक वक्ता नहीं होता है. अधिवक्ता का मतलब है यू आर रिप्रेजेंटिंग समबडी. अधि मींस टू रिप्रेजेंट समबडी.
हम लोग नॉर्मली भी रिस्ट्रेंट एक्सेप्ट किया अगर कहीं
नहीं,
कुछ-
नहीं,
हम तो ऐसे भी बीच में
देखिए,
नहीं
आपका
बोलते.
सारा सबमिशंस हम रिकॉर्ड किए हैं आपके सामने. कोई सबमिशन छोड़े नहीं है. सारा का सारा सबमिशन टाइप होकर अपलोड हो जाएगा. सीएवी नहीं करना चाहते हैं क्योंकि सीएवी के साथ भी ज्यादा दिक्कत है, भूल जाते हैं, बहुत तरह का बात है.
वी अंडरस्टैंड.
फाइल पूरा पढ़ के आएंगे. कोर्ट में हमको 1 घंटा लगेगा, हम लिखेंगे. उस समय हमको डिस्टर्ब मत करिएगा. आप रहिए चाहे मत रहिए. एक मिनट
ऐसे क्यों बोलते हैं? हम लोग कहाँ डिस्टर्ब करते हैं?
नहीं करते
नहीं
हैं.
करते. हम तो कभी नहीं करते हैं. हम तो ऐसे कहीं गलत भी लिखा जाता है तो बाद में परमिशन लेके कोई भी ऑन
नहीं नहीं, आपकी नहीं बात बोल रहे हैं, हम इन जनरल बोल
और
रहे
आई
हैं.
थिंक हंड्रेड फ्रेंड
कोई चीज
आल्सो
को इस तरह से नहीं करना चाहिए.
ये भी नहीं करता.
अभी सारा आ जाएगा और वो लिखाकर then we will be in a position to dictate the judgment.
नहीं, हम तो कभी उसके लिए कभी नहीं.
अभी ऑर्डर शीट हम नहीं दिखा पाएंगे, लेकिन बहुत सारे केसेस में बहुत सारे काउंसिल्स का आफ्टर कंक्लूजन ऑफ आर्गुमेंट उनका सबमिशन एट द टाइम ऑफ डिक्टेशन भी रिकॉर्डेड. ठीक है, these are all in black and white. इसीलिए आप हमको कलम में हम कमजोर नहीं है, बाकी किसी चीज में कमजोर नहीं है.
There are exceptions to everything.
हम लोग तो हुजूर है सर.
चलिए.
We are grateful. एक रिटर्न नोट्स दे देते पहले से as per डायरेक्शन.
आप रिटन नोट्स का
हाँ पहले जमा हम लोग कर दिए.
not required because I have heard you at length. I will not refer to your written notes at all.
From date is for finance to item 1, second field 129 of 1992.
There is one introductory application.
आइए तो what?
Substitution. Applicant number 1B. Chaman Mato. Service 2025.
Where is the respondent? Are you there for the respondent? Are you there for the respondent?
Yes, ma'am.
Do you have any objection to substitution?
No.
IE number 7246 of 2025. In essay number 129 of 1992 with the continuous. This petition, this interlocutory application has been filed for substitution of appellant number 2 with the bracket A, who is said to have expired on 19th of March 2025.
IE number 11839.
7246 is already disposed.
Specifically, IE number 11839 of 2025. For substitution of appellant number 1 within bracket B, who is said to have expired on 7/7/2025. The application for substitution was filed on 26/8/2025. The names of legal heirs and successors have been mentioned in paragraph 2 of the interlocutory application. The wakalatnama on behalf of the legal representative of appellant number 1B has been annexed along with the interlocutory application. The learned counsel appearing on behalf of the respondents has no serious objection so far as the prayer for substitution is concerned. Considering the aforesaid fact and circumstances, the ID number 11839 of 2025 is hereby allowed. Counsel for the appellant is directed to delete the name of appellant number 1B and insert the name of legal heirs and successors whose details have been mentioned in paragraph 2 of the intermediary application in reading during the course of the day. अब बताइए आगे क्या?
Yes, Blood, this appeal has been preferred by defendant respondent.
आप मेरिट पे सुन रहे हैं, ठीक है? With the consent of the counsel for the parties, the case is taken up on merits. बताइए.
Blood, this appeal has been preferred by defendant respondent. The appeal has been admitted in terms of dated 7/12/1993.
एक second, defendant respondent.
Defendant
was-
respondent. Appeal by defendant
Just a
respondent.
moment.
Suit dismissed. Appeal preferred by plaintiff was allowed.
Appeal allowed. Defendant in appeal now.
Yes.
Seven 1293.
Have you noted what the substantial question?
Yes. Can you read?
Now let the suit was read further. This appeal will be heard if it involves the following substantial questions of law. Whether in view of documentary evidence exhibit 1 being several decisions showing transaction between the parties establishing the factum of previous partition and showing that each partition in such partition being acted upon, the claim for partition and for title is barred by principles of estoppel, waiver and acquiescence, and is initiated under the provisions of section 52 and 116 of Evidence Act. Next, whether the suit being a suit for declaration of title upon adjudication of the real controversy with regard to the partition and for possession could have been termed to be a simple suit for declaration and could be dealt with under section 7 Roman 4C of the Court Fee Act.
You can.
Court Fees Act जो है 250 है. Therefore, ad valorem court fee is payable.
But for partition it is fixed court fees.
Only partition, then 250. Then fixed court fee. When there is declaration,
What was the court fees paid?
250. Fixed court.
In case the court finds that the court fees is insufficient, then under such circumstances that can be taken care of.
That was held by the trial court. And therefore suit has been dismissed on 2 grounds. Non-jointer of necessary party and court fee.
Okay. The suit will dismiss on
Yes,
these two.
yes, ma'am.
First appellate court.
Now, appellate court allowed without adjudicating the substantial question of law with regard to court fee. Now, important is to see the prayer made by the plaintiff.
Suppose this court finds that the suit was barred on account of the suit was faulty on account of insufficient court fees, but the parties have adduced evidence the court has entered into the merits of the case. What is the remedy? Can this remedy be cured now? Ultimately, if this court finds that this was the court fees,
I think that this was pointed out by trial court itself.
that's right.
But the remedy was not cured.
Remedy
But
was not cured. The first appellate court did not address it also.
Did not take.
Did not address this. Now, having this substantial question of law, we will address it. Right? We can address it.
Academic.
Yes. We will address it. Then under such circumstances, if we address this substantial question of law and if we find that ad valorem court fees is payable, can we still ask them to cure this defect? Because parties have now adduced evidence and findings have been recorded. Can this deficit in court fees be itself a ground for dismissal of the suit?
Not only 14, the first substantial question.
No, we'll come to that.
Yes.
I'm just talking about the second substantial. Suppose this court comes to a finding that court fees is insufficient. Then still, you can ask him to deposit the differential court fees. The first appellate court has not addressed this.
No, that not directed.
Not
To
directed.
pay. To
Not
pay.
directed to pay.
Not
Has
directed.
not addressed also this issue. Then, as per law, they can still be directed to pay the court fees within a stipulated time, whatever be the stipulated time, in order to have a decree. Suppose they are entitled to a decree.
But apart from other substantial questions.
Yes. That can
That
be
is
done.
our second direct.
That is permissible
Yes.
in law. Yes. उसके लिए भी कुछ दिखाना पड़ेगा क्योंकि हम जानते हैं कि ऐसा होता है लेकिन किस प्रोविजन में होता है हमको नहीं याद है तो वो आपको दिखाना है
देखना पड़ेगा ये सुप्रीम कोर्ट नहीं ऊपर ही एक जजमेंट है पंजाब और हरियाणा का शायद उस संदर्भ में काम आए और एक सुप्रीम कोर्ट का 2010 वॉल्यूम 2 है सुप्रीम कोर्ट केसेस पेज 112 लेकिन हमको नहीं लगता है कि उसमें उस तरह का कहीं है कि अगर कोर्ट के लिए डायरेक्शन देके सूट कैन बी डन
ठीक है देखते हैं अब आप बहस करिए Let us see. Yes, you are.
Let us proceed.
हाँ.
Yes. The prayer made in the plate was, it be adjudicated that since Nanku died in the state of jointness with his son Degar, who succeeded him by right of survivorship in the year 1952, and for former defendant number 6 and Lakia Devi, and after her death, for former defendant number 7, had no right title interest over the land possessed jointly by Nanku and Degan, and therefore the sale deed dated 5/5/1977 executed by former defendant number 6 and 7 in favor of defendant number 1 to 5 is sham, illegal, void, ab initio, a paper transaction without consideration, and is null and void and are not binding on the plaintiff.
I couldn't get.
Adjudication of title.
क्या relief है? क्या relief है सर? फिर से बताइए क्या है क्या story?
Now let once by amendment a further prayer double A was inserted. That it be further declared that the plaintiffs are owners of 1/3 share of the land owned and held by Heman in खाता number 17 of Villain Panara.
Trial court के judgment में तो नहीं है. The further prayer was inserted.
Just a moment. And 92 से ना ऐसा चेक हो गया कंडीशन
पैरा 1 में देखिए।
देखिए in our dream, degree of trial court is not there.
No, the entire relief has been quoted in para 1.
Yes.
It's quoted in para 1.
I have also made a note from that from the judgment itself.
There was no specific issue framed in connection with court fees. No, are the plaintiff Roman
Yes.
5.
Yes.
Roman 5. Record difference.
My brief depicts that there was an amendment by the order number 22 dated 18/4/1979. Date correct. But there is no other relief as submitted by me. Okay. Yes, Lord, I have got the amendment petition. The double A. It is dated 6/3/1980. इसमें डबल ए इंसर्ट हुआ है रिलीफ
ट्रायल कोर्ट में तो इसको कंसिडर ही नहीं किया इस इशू बना था।
At page 21, internal page 21. Is the suit maintainable in the present form? Is the suit barred by law of limitation? Is there any cause of action for the present suit? Is the suit defective or non-joinder of the party? Are the plaintiff entitled to get any relief or relief without paying ad valorem court? That is
ये
issue
जो
number-
1/3 शेयर बोल के तो कोई इशू ही नहीं बना ना।
issue number 5 तो है। Are the plaintiff 5
ये तो एड वैलोरम कोर्ट फीस का है। लेकिन ये जो आपका जो अमेंडमेंट करके जो आया है रिलीफ, ये ट्रायल कोर्ट के जजमेंट में कहीं दिख ही नहीं रहा है that there was an amendment. It is not there. You see, the entire relief has been quoted in para 1.
may be allowed to see the record
No, I've seen the
of the
plaint.
sheet itself.
Plaint में
कहीं
amendment
नहीं,
incorporated
नहीं,
है।
हमारे पास भी नहीं।
नहीं, plaint में amendment incorporated हम
हाँ।
चेक कर लिए हैं। लेकिन ट्रायल कोर्ट के जजमेंट में उसका कोई जिक्र नहीं है।
हाँ देख लिया, वो तो हम भी देख रहे हैं। वो तो हमारे पास
Maybe
भी
that the
check
trial court has omitted to see that there was an amendment in the plaint.
ठीक है। चार्ज करते हैं ये तो एविडेंस का है सब तक्कड़ हो गया थे
डिस्पोजल हो जाए तो गनीमत समझिए। सर आज तो टाइम खत्म हो गया, परसों सुनेंगे। सेकेंड हाफ में नहीं हियरिंग करते हैं सर,
देखिए
सेकेंड हाफ में ऑर्डर
सेकेंड पेपर बहुत सा फिक्स है इसलिए
फिक्स भी रहता है। और दूसरी बात जो एडमिशन वाले मैटर्स हैं,
एडमिशन है ऑफिस है
but we continue there. The hearing of the case has commenced. Post this case for further hearing. Day after tomorrow. तो फर्स्ट केस रखे हैं हम लोग, वो डिक्टेशन के लिए रखे हैं ना, एक डिक्टेशन। परसों सर डिक्टेशन देंगे पहले, उसके बाद इसके This matter is treated as